Good morning. Hello and welcome to today's webinar on advanced estate planning and strategic opportunities. We'd like this webinar to be very informal and as well as informational. So please put any questions you have in the chat. We're going to start today with the basics for estate planning and then transition to more advanced topics. There's three presenters today. My name is Burton, and I'm a tax shareholder with Lutz.
Ryan McGregor, consulting director. I'm within the M&A space and specifically valuation for the purpose today.
I'm Tom Hodgson. I'm an investment advisor on our financial team here.
So why are we here today? So we're here to talk about estate planning. Now, a common myth that we hear, or a common misconception, I should say, is that estate planning is only for the wealthy. I would say that's not true. And, for anyone that we work with, we like to talk to them about why they need an estate plan. First, you want to transfer your property as you wish. If you don't have an estate plan or documents for estate planning, then the courts are going to administer your assets according to the statutes that the state has in place. So you want to make sure that before you pass away, you're able to get those documents put in place. You want to protect your family and your beneficiaries. If you've got minor children, you're going to want to make sure you can name who you want as the guardian for those minor children. For those that might be inheriting your assets, you want to make sure you've got appropriate creditor protection put into place. And then, having an estate plan allows for a more smooth administration process as opposed to, unnecessary burden of going through the court system. If you were a business owner, you want to make sure that that business transfers to the intended recipients and you minimize any potential for disagreements, as well as, you don't want lawsuits to come into play just because you didn't have proper documentation in place before you passed away. And then the fourth one is to minimize estate taxes. Everyone talks about the federal estate tax. We're going to get into that in a lot more detail later. But for each individual, they have roughly $13.5 million worth of exemption, where if their estate's less than that, there's no federal estate tax that comes into play. But there are local inheritance taxes that will come into play. There's nothing for spouses, but for kids, if they receive over $100,000, there's a 1% tax. And then if there's other relatives or other friends that receive inheritance, there is local taxes of 11 or 15%, depending on the relationship.
So just kind of, we talked about this a little bit as we were putting this presentation together. Tom, just from your wealth planning expertise, why do people not do estate planning? Is it, one magic bullet, or does it seem to be a magnitude of a lot of things?
I think sometimes just like the concept of being distant, whether you're younger or, again, no one likes to think about mortality and life expectancy. So everyone always thinks, I can do this later. So it's not pressing right now.
Yep.
And then also, we talked about it right now. The current exemptions are 13.6 million per person. And everyone kind of thinks, well, if I'm under that amount, I really don't need to do much of the advanced planning. And that's where, again, as recently as, this most recent presidential term, there was discussions on lowering that exemption. So that's where, there's been cases that it was done previously is grandfathered in. So I think, again, we always say being proactive is probably the biggest piece of it.
Sure.
Because, you don't know what you don't know, and you don't know ultimately when things may pass, but having things in place kind of for that catastrophe scenario really just helps kind of get people some peace of mind as well.
Yep. So I think long story short, kind of what Ben mentioned, from an objective standpoint, it's figuring out what you have, protect it, and then obviously minimize the taxes.
And when we kind of go through again, obviously we talked about, we're going to start for the first 5 minutes is going to be kind of more the basic estate planning, so foundational pieces. We'll talk a little bit about, these documents here. We're going to send this out to everyone that's on the call, so we won't read through everything. But, wills, trusts, powers of attorneys, a lot of those trustees, that's the biggest piece. And then when you kind of think about the advanced planning, I'll have you go ahead and hit the next one. When you think about the advanced planning, we're going to talk about ways that you can make gifting of larger dollar amounts in use of your exemption. But there's also things that you can do that don't necessarily take up any part of your exemption. There's the annual exclusion. So right now, every person can give $18,000 away per person. So, if I have 2 children, I can give away $18,000 to each of them. If I'm married, my spouse can also give away $18,000 per person. So that can certainly add up very quickly as well. We've got a few other things on here too, funding 529 college education accounts, paying directly to, a health organization or a school. That doesn't count against your annual exclusion. So that's another way to gift additional assets, or again, spending it. That's kind of where, we're going to talk through, how do you know what you can give away or what you can afford to give away? Well, from our perspective, the financial planning is a big piece of it because, again, kind of back to Ryan's question, people a lot of times won't make a decision because you work your entire career, you get to this point where you accumulated your wealth. The last thing you want to do is give it away right away in day one before you know if you're going to be okay. But that's where, again, some of the planning that you can do ahead of time can help you feel comfortable, again, knowing how much you can afford to give away and what the benefits are of giving it away.
For sure. And like I said, the goal of this is more the advanced side of it, but just from a foundation standpoint, that's kind of what, Ben was talking about. Make sure that you get your wills, your trusts, your power of attorneys, medical directives. Those should be secondary to this conversation, but make sure you have those in place. Trustees, guardians, all that good stuff. So refresh any of these documents. We'll talk a little bit more in the end, but if it's been a little while since you put these plans together, they should be more living, breathing documents. So refresh them, make sure that if you still have young kids, it's the same guardians that you want to take over. If it's still beneficiaries you want to do, trustees, stuff like that.
And again, I think the big thing when you think about estate planning is making sure it's coordinated. So again, I think another way that we kind of help make this digestible for a lot of people that we work with is think in smaller increments. Yes, your estate plan is something that's kind of a big decision, but think of it in 3 and 5 year increments. Life is going to change. Your life is going to evolve. If you have minor children at some point, those, kids as they age may be more responsible to be some of your powers of attorney, your trustees. So think of it in kind of smaller bite-sized pieces. I think that's a way that people are, again, able to implement these plans because you can kind of think in some of these kind of smaller waves. The biggest thing, and obviously this was kind of on that previous slide, but the coordination, you want to make sure that all these things are coordinated. So obviously you're going to have wills and trusts in place. Another big piece of that is if you think of the beneficiaries. So click over here. Again, accounts specifically, you can have beneficiaries. And if those aren't working together, if your will and your trust say something different from your beneficiaries will actually determine how those assets flow. So it is very important that those are updated. Again, if you leave a previous employer, you go to a new employer, make sure your old 401k either gets consolidated or you keep tabs on that and you know how that's positioned and how that's going to be set to flow as well. And ultimately, again, you can have trusts in place and that's kind of where you can more formalize how you want assets to flow, because in the trust, and that's going to be something that you can set additional provisions. If you have minor children, what age are they going to be responsible enough that they can handle that? Maybe they have a trustee in place for a certain amount of time, and then as they get older, they can step into that role themselves as well. But again, I think that that's a big piece of it, and we'll talk more about some of the nuances of the trust and how they can work into your estate plan as we go forward.
One thing on the beneficiary designations that we see come up from time to time is in divorce. Making sure that when you name the beneficiaries of those, whether it's an insurance plan or a retirement plan, making sure those are up to date. Because we've seen stories where someone gets divorced, gets remarried, passes away, and they still have their spouse from a previous marriage named as a beneficiary, which creates a lot of problems down the road. So just another place where you want to make sure you've got coordinated documents and want to make sure you're updating them from time to time.
And again, we talked about this a little bit, but revocable trust can be helpful as well, especially as we start to move into the advanced planning. Revocable trust can be set up for you. It can be set up for your spouse if you are married. Having separate revocable trust can be helpful, especially when it comes to the advanced planning. Because if I'm planning to use part of my exemption to make a gift, I may want to have it titled in my name first before I make the gift. Otherwise, I may have to retitle assets and then ultimately make a transaction. We want to avoid a step transaction because obviously a lot of what we're doing with the gifting, we want to make sure that it can be upheld against an IRS, audit, refute, things like that. So this is where having a trust in place and having assets titled in those trusts can help simplify the process when you go to make the advanced planning. And then we are going to start to talk about more of the advanced planning strategies. I think one of the big things that's worth mentioning, and we're going to talk about this probably a lot and come back to it a lot, every situation is unique. And I think that, big thing is working with your professional. So obviously, if you work with us, consult any one of your professionals here. Your estate attorney is another big one that you want to have involved throughout the process. And again, I think this is an area that every situation being unique leads to different outcomes, but the correct planning can accomplish whatever your goals are. And it's not our job to tell you what your goals should be, but we want to educate you on, what your options are and help accomplish those to, again, minimize taxes where we can and help control the flow of assets to where you want them to go.
And that's perfect. And that nice segue. I think at this point in time, when you go from basic, right, your wills, your revocable trust, into something more advanced, you need to start putting that team together. And it doesn't have to be, terribly complex or spendy at that point in time, but you probably do need, a legal mind, some sort of an attorney to help you out, some sort of a CPA, maybe insurance, wealth advisor, could be other owners in your business if you own a business, could be other family members, could be employees, whatever it is. Start building that team of people that you believe, and understand your situation. Transparency is important. Not everyone needs to see the same transparency at the same time. But as you move through this plan, transparency is important. So then if something was to happen, it can be then easily rectified, either through wills, trusts, or whatever it is, and flow once again. Once again, the objective is to flow the assets the way that you intend them to be flowed. So once again, purely from a planning standpoint, you get into it, you say, okay, what do I want to gift? What do I want to give away? You got to start with where your actual core capital is, right? What is your personal balance sheet as it pertains today? If it's just cash, marketable securities, maybe it's business interest, maybe it's real estate, maybe it's Bitcoin, jewelry, whatever it is. But at some point in your life, when you start doing this, you should probably put some sort of a personal balance sheet together. Figure out where all those plans are at. It's life insurance. And have that readily available for you or your advisors to kind of help you with that guidance. That then moves into, okay, what do I actually need to, in my next phase, if I'm in my working career and I'm looking to retire and I go into that next phase, what's my lifestyle spending look like? What do I really, really need dollars and cents wise? And obviously Tom and his team can help with that. And there's a lot of advisors that can help with that modeling, but that's kind of that next step. It's not always terribly complicated, but what is complicated is what is that actual dollar amount? And so we talk about 90% of confidence. Really getting the nuts and bolts and what you want to do. Do you want to, once again, you built up, like we talked about earlier, you built up this company and you're going to sell it for $10 million and then you're going to go and travel the world. Well, that might run away very quickly, right? You might erode that capital away. The flip side of that is if you sell that business and then you just kind of sit at home, you probably don't need as much as you even had when you were actually working. So it's a personal decision, it's a personal capital, but starting with this core capital, what do you really need in your lifetime? Within, once again, some sort of a confidence level that you feel comfortable with, and then some sort of reserve, some sort of a buffer on top of that. After that, that's kind of what we're talking about. That's where you start getting into that excess, the discretionary. And then it gets into, who do we want to maybe give that to? Is it kids? Okay, if we have such a wealth, that even the kids, are going to be in this potential tax issue. Maybe it becomes generation skipping. Maybe it goes to the grandkids. Maybe it's a situation where I have a really good cause that throughout my life that I really would like to give some money to. Maybe it's a charity, foundation, whatever it might be, other pursuits. Maybe it's, college foundation. That's where we really want to get to the part of this conversation is that discretionary capital. But doing this legwork needs to be done first before you get into and say, I can give $10 million away. Well, if you're planning on running through all of your capital within 5 years, you don't want a reverse gift. You don't want to have to, live tight your last, handful of years because you gave too much money away. So
Ryan, you hit on that, but I want to just emphasize that this is the first thing that we do when we're working with clients is taking, your balance sheet, looking at it and projecting it out over the next 30, 40, 50 years and saying, what does it look like? Am I going to spend this down? Maybe I don't have an advanced estate planning issue, or maybe I see my balance sheet continue to grow. All of a sudden I'm looking at this at my age, 85, 90, 95, and I've got an estate tax problem. I think doing that planning on the front end, again, gives some peace of mind. So then that way it's not quite the same, again, mental hurdle to make a gift. And especially when we start talking about some irrevocable gifts, it makes it a little bit easier to feel comfortable making a gift. Once you know that, my goals are safe, I've got those protected, to a high degree of confidence. So that way, I'm not stressed about, what happens 10 years from now, 20 years from now, because we've kind of gone through that modeling.
for sure.
I think that's, in a lot of clients that we work with, their mindset has always been, I need to keep growing my balance sheet. I need to keep growing my company. And so once they get to the stage in life where they say, okay, either I'm going to sell the company or I'm going to retire, and that shift in the mindset from trying to grow my personal balance sheet as much as possible to, okay, whether it's giving it away or it's watching it, start to get depleted as we're spending down, our life savings. I think that's a big hurdle that we try to work with people to get past. And estate planning, there's always that fine line of, how much can I give away versus how much do I feel like I need to maintain as my core capital. And when we work with people, it's like, hey, we don't want you waking up 6 months, a year from now and saying, oh my gosh, I'm looking at my personal balance sheet and I think I gave way too much. We want to make sure that we, walked everyone through and everyone's on the same page and comfortable with, yeah, we can give away this amount and be comfortable down the road.
Sure. This is what we want to do is just a quick little example kind of showing how something like this would work when we worry about you have obviously your core bucket, your excess bucket, and we say, okay, from a control standpoint, and we'll get into that and how you want to do, if it's voting, non-voting, recap, all that stuff. There's a control aspect to this, but in this scenario, we want to say, okay, we have these assets, we have this excess, we have this core. How do we get that excess as fast as we possibly can outside of our estate? And there's different, trusts and mechanisms, but in this situation, the grantor in this scenario wants to pay the tax. So we say, okay, let's take this excess and let's go ahead and shift it through an irrevocable gift and get that out of our estate. In this situation, like I said, the grantor is going to be paying the tax, and we want that capital to appreciate as best as it possibly can so it can grow outside. So this is, once again, maybe it's real estate that you think is going to blow up. Maybe it's marketable securities that you think are going to take off someday. Or maybe it's that business asset that you've been grooming for a while, but you really think that once again, it's just going to grow. These are things that we can kind of out of the estate through obviously the help of your advisors. Once again, the grantor, the one that's making it, still gets the chance to pay the taxes. You're not putting the burden on the person that's getting or the individual's getting it. But then these assets, the goal is to, once again, that they are then frozen at that point from an estate standpoint, but then are able to gift and appreciate outside of the personal estate. So
yeah, so kind of, we just make up an example here. If you said, okay, hey, I've got in my excess capital bucket, I've got this real estate and the value today is $1 million. And you say, okay, I'm going to get that either into some type of irrevocable trust for my kids and grandkids, or directly giving it to them outright. And now I've got that off my personal balance sheet. It's no longer an asset that's in my estate that would be subject to estate tax. And so then we hold that piece of ground that was worth $1 million for 10 years. And suddenly it was right outside of Gretna, and now there's a significant development use for it, and it's valued at $10 million. That $9 million of appreciation, that all happened outside my estate. And so there's no clawback, where there's no tax that would then be assessed on me pushing that out to the trust, because it's locked in on the date of the gift. It's not something down the road. So, getting these assets out today for something that's going to significantly appreciate really helps save on the estate taxes down the road.
I think you hit on a big thing here, and again, kind of back to sometimes people don't make a decision because they don't think they have an estate tax problem today. But that future growth, if you can capture that outside of your estate, then you can pass that to the next generation or the generation after without any additional estate taxes. I think that's a big piece, that the advanced estate planning isn't just for ultra high net worth individual. It's kind of for anyone that's in that range, that they have, accumulated wealth and they want to do something to make sure they're preserving it. Because also, once you make that gift, you have already used that exemption. Now, if the estate tax laws change, they come back down, you've already pushed it over. It's already outside of your estate. That can't any longer be subject to your estate taxes. So I think that's a big point there. Your example was a great example, because it kind of leads into, what might be come in the future.
And that, once again, perfectly ties into this. Hopefully everyone can see it. I know it's kind of a little bit of a lot of data here, but what we want you to take away, the biggest thing that we want to take away is roughly a 25-year look back, right? It's 2000-ish, all the way up to what we think is going to sunset in 2026. The name of the game is that it's ever changing, right? Obviously, tax laws change, Congress changes, who's in power changes. It's constantly changing, right, every 4 years. So depending on where the future holds, and if you had that, magic 8 ball and you knew where it was going to go, then yeah, you could plan for that. But if you, let's say in 2002, and you had a $1 million estate exclusion, but you had $10 million in your estate, and you had no other mechanism, there's other mechanisms from an advanced standpoint, you might be able to sell some of that. But if you did, and you passed away with $10 million and you had $1 million exclusion, that $9 million was going to be taxed at 50%. That's a huge tax. It's a huge tax. So what we want, biggest thing we want to take away is, once again, the past, not that long ago, was very, very minimal from exclusion, all the way back in 2010, where it was actually repealed for a period of time. So that's important. This isn't to scare anyone. This is actually just to purely show the facts that, just like I said, not very long ago, it was very, very minimal. The other parts of this is then, obviously, in 2011, there's affordability. So now you have, a spouse, at least you can gift within that portability, unlimited portability. That's important. So then, if by chance there is an exemption that is left over from, your previous spouse, you can use some of that as a portability standpoint. That's obviously very important. The other major kind of, once again, drill of this, and we'll probably talk about it more than you guys want to hear, is the sunsetting. Right now, where it sits is an exclusion for an individual person, roughly $13.5 million, 13.6. So if you were married, you're closer to 27 million when this is all said and done. Okay, 26, 1/1/26, everyone thinks that it may sunset. Unless something happens, it will sunset. So at that point in time, there's going to be inflation. It's roughly 7 a person, or 14, from a couple standpoint. So the biggest thing in this is, if you are in that 7 as an individual or 14 as a couple, standpoint, I'm sorry, 20, 26, 27, whatever it might be. If you believe that you have $50 million, then you clearly need to be doing, there's no question, you have to be thinking about this. If you're in that middle tier, then you have to start thinking about what Tom said. Are the assets that I have, can they blow through the appreciation in 5 years, 10 years, 15 years? Or is it just a situation where I'm just preparing for what could be, right? My business is just taking off, but at some point in time, I think I might hit it big. These are all things that, once again, from your advisor standpoint, you need to be kind of thinking through. But it's also just simply putting that team together, once again, that they can help you guide. You don't have to be the expert in this. That's not the point. You just have to say, I'm willing to at least have the conversation. I think that's one of the bigger things on this situation is if by chance it reverts back down to the sunset and it's back to 7 a person as opposed to the 13.6 we're talking about. Okay, now what does that mean? Does that put me in this estate issue? Or from a gifting standpoint, does it put my kids in an issue? Those are ultimately, like I said, the conversations that you need to be having from an advanced standpoint. We would love to know what it's going to be when we die, but none of us are going to know. And so we know the exemption is as high as it's ever been. We know that there's going to be some sort of a crunch come 1/1 of 26. And ultimately, that's what this kind of presentation is about, is starting to put that thought process in so you can get the mechanisms in place, the trust in place. So then when you decide to jump next week or a year and a half from now, you're ready, your advisors are ready, and you're prepared for it. So there's a lot of things that go into that slide.
And again, I think the theme here is that being proactive will pay dividends.
Yep.
Because everyone is going to be thinking about this in November of next year. That's going to be too late. Your estate attorney is going to be booked. You're not going to be able to get a valuation done. So to have everything done properly, you really want to be thinking about this ahead of time, because there are going to be other things that may take time to get done. You know, appraisals, everyone who's out appraising properties or values, they're going to be backlogged as well. So being proactive is going to matter. We'll kind of talk more about some of the operational side of it as we go through, but I think that's a big takeaway. Just being proactive is going to put you in a better place that once this is kind of scheduled to sunset, if it does, you're ready to go. Or conversely, if new legislation comes into, discussions, and all of a sudden they say this is going effective at X date, again, being proactive ahead of that, you're kind of already loaded, ready to go. So that way you can make the decision without having to, at that point, not try to play catch up.
Yeah, and I like to define sunset. Sunset means, unless Congress acts and puts a new law in place, it is going to revert. Back in 2018, when it went from 5.49 million to 11.1 million, that was because a new law came into play. Same thing in, back in 2011 when it went to 5 million, a new law was enacted. So sometimes, we try to plan because there's a new law coming into place. The law is going away, and, as of today, it'll be gone on 12/31/25. And if you haven't done any gifting before then, now you'll be subject to the new limits. So this isn't, when you hear people talking about the sunset happening, it's not that they are worried that Congress is going to enact new legislation. It's that based on the current legislation, it goes away on this date. So I want to make sure everyone understands, when you're looking at the gridlock in Congress, we know it's going away unless somebody, enacts a new law.
Yeah, I think that's important because to that point, right, there's a lot of times we do planning. It's like, hey, the what if, but to this point, unless something changes, it's going to happen. So then once again, we jump from basic into kind of this intermediate, and it doesn't necessarily have to be intermediate for other people. It could be, well advanced. This is just not common for everyone. But when we think about the first, one, let's just say the LLC. From a valuation perspective, we do a lot of valuations of LLCs that could be just simply land, right? You have a family farm that you want to make sure that you press down to the next generation. So in that situation, instead of gifting it directly, maybe whoever owns that land would like to have a little bit of control still. So they drop it into this, instead of a direct gift, they put it into the LLC. And then maybe what they do is they separate Class A and Class B shares. From that standpoint, Class A is voting, for instance, right? Has all control on what happens with that LLC, as well as those assets inside that LLC. Class B can be non-voting, and that might be just, you know what, I have economic interest in this, but I really don't have any way of selling it, transferring it, and all that stuff. And so from my perspective, when you give me, this LLC and you give me the financials and the organizational documents and say, hey, I'd like to value this company. And I say, okay, what's the interest for? Is it for the whole company and I'm going to sell it? Or is it for, say, a non-controlling interest? So once again, if I'm going to give it away probably non-controlling interest if I have the ability to kind of make sure I have the biggest bang for my buck. So if that's the case, I can say, okay, that individual that's now a non-controlling owner cannot liquidate the company by themselves, can't kick out distributions by themselves, can't take on debt to then kick out distributions, can't probably transfer without other owners within that organization saying, yeah, that's okay. Well, if that's the case, inherently that value for that unit or interest or share is not the same as someone that has control or 100% control of that LLC or direct gift of that real estate. So in those situations, various discounts can range anywhere between, 70% on the dollar, 70 cents on the dollar, all the way up to 90 cents, depending on it. Marketable securities are obviously a lot more liquid, right? So you're not going to get as big of a discount. Raw land in a hard developed county in Nebraska or somewhere, yeah, that's going to have a harder market for it. So therefore, there might be a bigger discount for that. So that's where I've seen a lot of the LLCs, and not just that. I mean, there's obviously a lot of operating companies that are LLCs. But where I want to go with the LLCs is I see a lot of wrapped assets in that LLC where you drop an asset and then you try to maximize the discounts from that perspective.
A lot of our clients that we work with say, we've got a strong balance sheet, we're ready to give, but we don't think our kids are ready to receive those assets today. And so, as Ryan's talking through funding an LLC and gifting LLC units, it's not necessarily something where, hey, we've got to gift these LLC units directly to our children. We can set up trusts, and depending on the type of the trust, we can structure it such that the beneficiary probably doesn't even need to be aware that the trust exists today. And so as you guys are thinking about your own personal situations and saying, okay, well, gosh, I've got some kids that are responsible, some kids that might not be, we talked a little bit about transparency at the beginning. It's like, okay, how transparent do we need to be with our kids today? And maybe the answer today is we don't need to be transparent at all. They're all under 18. Mm-hmm. Maybe, you look at a 5 or 10 year period goes by, and then all of a sudden it's like, okay, well, our kids can start seeing a little bit of what our balance sheet is, but we don't need to show them the whole picture. And, another 5, 10 years passes and you can, keep peeling away at the onion, letting them, find out more about the family balance sheet. But to Ryan's point, we're comfortable doing gifting now rather than gifting $1 and it impacting our exemption $1. We can gift these LLC units where the underlying asset's worth $1, but from a gifting perspective, we've only gifted 70 cents. Yep. So just trying to maximize the benefit of transferring those assets.
And Ryan, a couple of questions for you that I would be thinking of if I was a viewer here. When you're going to be making a gift, how soon or how close to the gift does the valuation need to be? Can I make a valuation today and then gift it December 31st of 2025? Or does it have to be relatively close in time? And then the second question is, once I make a gift, how long does the IRS have to come back and challenge that or audit that?
Good questions. So from a timing perspective, there's no magic timing. Ideally as close to the gift as possible, right? Because what you don't want is if you do have, let's say it's a business operation, every day changes, you might hit a really big opportunity, a week from the gifting, or you have that opportunity. So if you can do it as close to gift as possible, it limits any risk of a look back. If it's real estate and you have a real estate appraisal, right? And you say, all right, I got my real estate appraisal today. I'd like to gift tomorrow. We can do a valuation in a very short order. That's a very tight window. If you say, I'd like to do the valuation today, but to your point, probably going to sit on it for about a year, year and a half. It's too long of a window, more than likely. I mean, a hypothetical rule of thumb, maybe 3 months, 6 months, depending on it. Operating companies are different because they're ever changing, right? And so what you don't want to do is you don't want to value it and then once again have the ability for the IRS to look back, because they do have 3 years to look back. And that is from the actual filing of the gift. So even though you say, okay, technically I drew up the documents and transferred today, if you don't actually file it for a period of time afterwards, clock doesn't start until that point. So when you have that 3-year look back, they have the luxury of the hindsight. So there's, it doesn't help to do gamesmanship and be like, oh yeah, I value my business is $1 million, but I know that I have that contract locked up tomorrow and my business is going to go like this. We always ask for projections. We always try to ask for that because we want to make sure that the client and the valuation is protected as possible, so it doesn't have any holes to get poked in. So to your point, as close to possible as we can get, 3-6 months ish. That's our ideal. If we do a valuation, because we'll have a lot of attorneys that want us to do just, hey, can you give us a 30,000 foot value so we can help with that planning? Those are easier to update, right? Because we've already built the model. We've already kind of done that planning. And so then all of a sudden we say, hey, we're going to gift in a week from now. Perfect. Then let's get as close to financial as possible. But just remember that 3-year look back. The IRS does have that little bit of hindsight. Now value is still as the date that it was technically valued. They're always going to have a little bit more ahead on us with the hindsight.
Yeah, we don't really get into the reporting side of things, but to your question, any gift that's transferred during calendar 2024, you'd be filing a gift tax return, which is due April 15th of the following year. So it'll be April 15th, 2025. It's got the same extension abilities as your personal return does. So you could file an extension and then file the return as late as October 15th of 2025. And then the IRS has 3 years from when you file to then go back and audit that tax return and try to adjust the value that you've given for those assets that were transferred. So
On the Roth side of it.
Yeah, and then so again, kind of the third bullet point on here, converting pre-tax IRAs to Roth. If I have a large, let's say that I'm a doctor and I've got a very large 401k and I've done a lot of great savings and deferring, that is a taxable asset to me or to the next generation. If I'm above the estate tax threshold, it doesn't make sense for me to leave the full balance of the IRA in there, pass it to the next generation. I would pay estate taxes on some portion of my estate, and then the next generation also pays income taxes on the IRA. I may want to, again, convert some of my pre-tax IRA today. I'll pay the income tax, but then if that income tax amount drops me under the estate tax threshold, well, then now my estate does not have any tax bill because I've dropped it under that threshold. So again, there's going to be a lot of different, varying components here. And again, we'll kind of talk about this a little bit later on, but IRAs can also be a good tool to use if you're charitably inclined, and that may be the best way to, again, minimize taxes to yourself and the next generation if that's a goal of yours.
yeah, I think when you're working with your advisors and you're looking at your personal balance sheet, there are certain assets that should be, tagged for charity. There are certain assets that are better going to, individuals. Just, there's a concept called a step up, a basis step up on debt. So, if I have a publicly traded stock that has low basis, that's an asset that would be able to be stepped up to fair market value on debt. And so if I receive that stepped up asset as a beneficiary and turn around and sell it, I'm not paying any tax on that transaction. Whereas if I receive an IRA, those dollars aren't eligible to be stepped up. And so that would be taxable income to me as the beneficiary. So kind of, again, working with your team, looking at your balance sheet, figuring out which assets might be the best to transfer to individuals or to the charities. Definitely another key thing to be looking at. So we've got a couple different trusts that we work with quite a bit. So we've got a GRAT, a SLAT, an IDGT, which I call an IDGIT, and then an ILIT, ILIT. So we're going to run through these pretty quick. They get pretty technical, but just to give you guys an awareness of a couple different types of trusts that are out there. So a grantor retained annuity trust. So the grantor is the one who's establishing the trust and contributing the assets. So if I, as the grantor, establish a trust and I transfer an asset to it, and in exchange, I'm going to receive an annuity back from the trust. So oftentimes, you know, the easiest way that we think about these is like, hey, this is similar to, I talked to my financial advisor and they said, hey, you can spend 500 grand and get a 5-year annuity where you're going to get 100 grand back each year. So when you set up one of these trusts, they typically have a 3 to 5 year maturity to them, where you say, okay, I'm going to put my S Corp stock or my LLC units into this grantor retained annuity trust. Now the trust owes me an annuity stream back for that period of time. And then once the trust has matured or hit that 3-year timeline, whatever assets are still in that trust, then pass out to the beneficiaries or pass out to a different trust. So oftentimes when we use these, we'll zero out the net gift. So when I say zero out, you know, if I put 500,000 in and I get 100,000 back every year, and you know, there's interest payments and whatnot on that, but really I haven't given anything the full 500 back. So from a gift perspective, there's a calculation you'd have to run, but those are going to go, it's going to say net zero. Whereas I could also just say, hey, you know, I've got 250,000 of exemption remaining. Let's use up the rest of the exemption. Well, now maybe I do a $500,000 transfer, but only take back a $50,000 annuity. So one thing to keep in mind with these GRATs, and we haven't really got into this much, but there's a concept of generation skipping transfer tax. These GRATs aren't eligible to receive that exemption. So if you were trying to do more generational planning to where you were going to have this asset go to, you know, grandkids or great grandkids, future generations down the road, this wouldn't be a very good tool to use because it would be subject to that GST tax down the road. The spousal lifetime access trust. So this is a provision that you could add to an irrevocable trust to allow your spouse to have access to the funds in those trusts. So with some clients, when we're working with them, you know, it's, hey, we're ready to do some gifting, but really we're just not totally comfortable with that being a permanent asset that's totally gone that I'll never have access to again. And so if you add this SLAT provision, the spousal lifetime access provision to the trust, you know, it's a gift that's for my kids, but my spouse kind of has a backdoor access to get those funds still. So this is one that we've seen. It's a fairly new concept, but it's one that we've been working with for the last couple of years. You have the intentionally defective grantor trust. So this is one where I've gotten the asset out of my estate, but I'm still paying the tax on it. It's got grantor provisions such that I'm paying the tax. Frequently, it'll have something called a asset substitution power where, let's say I put my S Corp stock into it and then I say down the road, really, I want that S Corp stock back. I can replace it with an equal asset. So there's typically a couple provisions in that trust agreement that give it this grantor powers. This one we see used a lot with people that are over that 26 million, where you start talking about trying to transfer, significant value, tens of millions of dollars, 50 million, $100 million companies that you're trying to get outside your estate. And we see a lot of those clients using these idiots.
And I think that ability to substitute assets, I think, is extremely important, because to that point, we talk about, you can go back to the first part of this, right? Figure out what your core assets are, your excess assets, and where do you want those assets to go. But a lot of people kind of get stuck on that control aspect. And so this could still be a situation where you utilize that asset to originally do that, but then you go, you know what, I'd really like that asset for whatever purpose that I want back into my estate. Now I'm going to substitute for equal, right? So if I have a note for 10 million and I check back 10 million of stock, right? I have a note and I have 10 million. So I'm still at that zero, quote unquote, from the estate side of it. Doesn't necessarily mean I brought that back in and I added value because I replaced it with something else. But for whatever reason, maybe you want to sell a company, you want to do whatever. Sometimes it's easier to bring those assets back and substitute.
I think one other thing that we had kind of said throughout, but I just want to reinforce here as well, you can sometimes pair multiple strategies together. So like the LLC, you may be able to structure as an LLC, gift those LLC units into one of these trusts, get a discount on the front end. And then again, obviously you still potentially have some trapdoor access. And I see we have a question.
So the question is there a limit to gifting property to a parent? So this is, the limit is the same, whether you're gifting what I'll call upstream to a parent or downstream to a child. And then the question also is there incentive to get a basis step up on death? So you could, if the child was wealthier than the parent, or if there was just an asset that the child wanted to get a basis step up on, you would be able to gift to the parent and then get a basis step up on death. One thing to be aware of on this would be to make sure that there's agreements in place that asset comes back to you on death. Because let's say you've got siblings, you gift an asset to the parent, there was no, documentation as far as how that was supposed to be handled from estate administration purposes. And then, all of a sudden your siblings are saying, hey, this was mom's asset, it's not going back to you. So something that you could employ if you wanted to would be to do that upstream gifting. Another type of trust that I wanted to put in here was a dynasty trust. So a dynasty trust would be one that's for future generations, not just for kids, but for grandkids and beyond. And so that would be a trust that you're utilizing your GST exemption on. And so oftentimes it'll be like, hey, we're gonna do this intentionally defective grantor trust. It's gonna have a SLAP provision such that my spouse can get access to it. And it's also gonna have dynasty provisions such that it can go to future generations without there being that GST tax on it. So like Tom said, some of these kind of stack up on top of each other. The life insurance trust, we'll see that, if you've got someone whose personal balance sheet is $10 million and they've got a life insurance policy that's 5 million, well, that 5 million of life insurance proceeds is includable in their estate unless you've got it in this separate life insurance trust. And so that's one where you can either transfer an existing policy, and there's some complications around there where you've got to wait a certain period of time, but unless it will get pulled back into your estate, or you go take out a new policy inside of one of these trusts to where that $5 million is no longer pulled back into your taxable estate at that point. And we're going to go through this charitable trust concept,
Yeah, and since we talked about this a little bit, I probably won't spend a ton of time on the charitable side of this. But again, I think this is where some of that initial thought and planning comes into play. If being charitable is one of your goals, quantify that ahead of time and then figure out what the best structures or asset is to fund these different types of vehicles. Again, you could even have it in your estate. Let's say that you're right on the borderline of the estate exemption. You can specify, if you have that, any amount above the exemption goes into one of these type of structures to give that to an organization, and then instead of it being subject to the 40% estate tax. So again, work with your advisors, quantify what these goals are, and figure out what the best investment vehicle or entity type is to accomplish these goals.
Yeah, so Tom touched on the private foundations. I mean, just so we present this, most of the time we're not going to recommend a private foundation unless there's $10 million of assets at play. They're heavy administration, just a lot of things go into those private foundations. So if somebody's got $10,000 that they're looking to give to charity, private foundation's not in play. I mean, it's got to be someone that's got a significant amount of assets that they're looking to contribute to that private foundation. We don't have it on the board here, but a donor advised fund, I think a lot of our clients that we work with utilize those to where you get a federal income tax deduction when you put money into a donor advised fund, but then you don't have to distribute those dollars out right away. So if you've got some type of a liquidation event happening in a certain year where your income is going to be super high, working with your advisors to figure out, okay, how much should I be setting aside for charity this year to get the maximum benefit, and then ultimately down the road, figuring out how you want to divvy up that money is something else you can be thinking about. So the CRT, the charitable remainder trust, this would be, I have an asset, I want to earmark it for charity, but I want the charity to get the remainder, and I'm going to receive back a stream of payments every year. So a lot of times when we're working with clients on these, it's either a 20-year term or a lifetime term. And so, we'll put an asset into this trust. Again, there's a charitable remainder annuity trust. So think of it as in, hey, I just bought a 20-year annuity. Well, at the end of that 20-year term, whatever assets remain inside the trust then get paid out to the charity. And so this is another one of those, concepts where we can structure it to where the annuity goes to mom and dad. We could do a charitable lead trust where, maybe it's going to that's the inverse. So charitable lead, the annuity stream is going to the charity, and then the remainder goes out to beneficiaries. So, these are concepts that you don't see frequently, but, when the assets are right, when the client, is of the right mindset, it's something that can be pretty powerful.
Sure.
Yeah, so now we're gonna take just a brief break. And here's gonna be a question to get CPE. So if you're listening and want to get CPE, please email Reagan.
What if you put no?
I think you just answered that.
Okay, so some other considerations. So on the tax side of things, if I do a gift today, that gift receives carryover basis. So, from our earlier example, we said we had ground worth $1 million. So let's say I paid $1 million for that ground. The basis that the trust is going to have in that ground is $1 million. So if down the road the trust then sells that ground for 10 million, there is, 9 million of income that would be subject to income tax. So if it's held inside my estate, it may be subject to that 40% estate tax, but I might get the basis step up. So it's, one of those things where planning comes into play, and is it better to get it out of the estate, or is it better to get the basis step up? And that's another piece where that asset substitution provision inside some of these trusts can be pretty powerful, where you've got a low basis asset inside the trust, and now you're going to replace it right before you pass away with a high basis asset to get that basis step up on the S corp stock, the land, the LLC units, etc. So just keep in mind, there is no basis step up on assets held outside your estate. With S corp gifts, so if I'm gifting my S corp stock to a trust, distributions that I might have previously been using to fund my lifestyle are now going to go into that trust, or distributions I was using for, to make the tax payments are now going into that trust and are no longer for the grantor. So, if Tom had an S corporation and he put it inside of a trust and it has $1 million of taxable income, well, Tom's going to have to come to the table with $400,000 worth of tax dollars. And if the S corp makes a distribution of, 500,000, that's all inside the trust now. So Tom's going to have to use other assets to make those trust payments. So, making sure that when you're doing your planning up front, that you've got the cash flow considerations done properly. And then, with trusts, there's only certain types of trusts that can own S corp stock. So just something to be aware of. That's kind of more for the advisors on the back end, but there are a lot of complexes and nuances with S corps and the gift planning.
And I know we have about a minute or so, so I'm just going to run these last two fairly quickly. Once again, anytime that you bring in multiple people into either an LLC, business, all that stuff, you really should be starting to think about those 5 Ds. Obviously, we've been talking about the estate side of it, but once again, as you start bringing in, maybe I'm going to do that non-controlling gift to my kids. Well, now they are part of the entity, right? So You got to think about the disability aspect, the disagreement. And unfortunately, you had to think about divorce as well. So it may not be, hey, my kid, yeah, but unfortunately, if something happens to that kid, now what happens if they get divorced? So always keep in mind, anytime you do planning, you have to think about the 5, 10, 15 extra steps that come with that. And then lastly, from a consideration, obviously, we've been talking a lot on that sunset, but once again, Tom hit on it, but there is going to be a significant crunch on advisors in the next, 18 or so months. So think through those, make sure that you're planning, make sure you get the trust, but obviously plan ahead, get that taken away and say, you know what, let's just get the trust set up and then maybe I can fund it whenever, right? It's easier that way. Revisit old documents. It's got to be, like I said, as best as possible in that 2 to 3 year look back, keep those living, breathing documents, and then make sure you put that team together from the consulting standpoint, make sure those advisors ready or to go, and you're not calling them at, 12:20 this next year and trying to figure out how to get. So obviously, thanks for everyone for listening. There is one question. The 5 Ds, it's going to be death, disability, disagreement, divorce, and distress. Once again, obviously, thanks for everyone's time. We appreciate it. We'll shoot these slides out to everyone, but don't hesitate to reach out for additional questions. We'd be happy to take some offline questions as well.